Hello, my name is Izznayli Nur'asyrani binti Asli, and in today's presentation, I will be focusing on what are fittings and fixtures and providing my advice to Abraham in his issue. So first of all, what are fixtures and fittings? Fittings, or may otherwise be known as chattels, are items that are removable, and they are items that are not fixed to the property. For example, fittings or chattels may be wall art or freestanding curtains. Whereas on the other hand, fixtures are things that are affixed to the property or to the land, that it forms the land itself. And this would expand as to boilers or dishwashers. Now moving on to focusing to the main issue of this problem question. So how does the law apply to Abraham in the case of his context? First, we now look onto the question of whether the paintings and the sculptures are mere chattels to the property. So, first, in terms of examining the degree of annexation and purpose of annexation, in determining whether a chattel may become a fixture, this is illustrated in the case of Ellistone and Morris 1997, where Lord Lloyd had argued that it depends on the circumstance of each case, but mainly on two factors, which are the degree of annexation and the purpose of annexation. Degree of annexation places an emphasis as to what extent has the chattel become attached to the land. The firmer, the higher chances has become part of the property. On the other hand, the purpose of annexation is for the courts to place consideration as to why the chattel was attached to the land in the first place. The case that we will be looking on to test the degree of annexation for a chattel becoming a fixture is when it is physically attached to the land, is explained in the case of Holland and Hodgson. So, in the facts of the case, the owner of a mill had installed looms, which were attached to the stone floor by nails driven through holes in their feet. And the principle that was laid down in this case is that an article that is affixed to the land, even the slightest, is considered to be part of the land unless there are circumstances to show that it was intended to continue as a chattel. There is a burden or responsibility that lies to show that if it was intended to be a chattel, owner of the land must bear this burden. And Blackburn J had also argued that although the nails on the looms were easily removable, the looms were fixtures by no means. Next, we will also be looking at if a chattel is attached to land with an intent to enable better enjoyment, it will not be regarded as a fixture and would remain as a status of personal property. This was understood in the case of Lay and Taylor in 1902, where the tenant for a life of a mansion had hung valuable tapestries in a drawing room, and the House of Lords concluded that the tapestries were chattels, as they were not intended to form structure of the mansion and were attached simply for the better enjoyment as ornamental decoration. However, contrastingly, in the case of Daincourt and Gregory in 1866, tapestries were actually considered to be fixtures, and this was because they were attached as wallpaper. Lord Hasbury argued in the Taylor's case that the difference in judgments for both cases was due to the change in fashion and attitudes to styles of decoration. The degree of annexation must hand in hand be tested further with the purpose of annexation to determine further how a chattel may be regarded as a fixture by looking through the degree of chattels resting on land. As mentioned before by Blackburn J. in Holland and Hodgson, articles not otherwise attached to the land by their own weight are not considered as part of the land, unless the circumstances were intended to be part of the land. There is the onus of showing that they were intended lies on those who assert that they have ceased to be chattels. In an essence, the degree of annexations holds the shifting burden of proof as to how the items attached to the land are presumed to be fixtures unless a contrary intention is shown, as shown in the case of Hemp and Bygrave in 1883. The vendors of the land had a number of items removed from the garden, such as statue, other stone ornaments, after entering into a contract with the purchasers. The items removed were fixtures despite them resting on their own weight because they had formed, quote on, the part and parcel of the garden and had been installed to the garden in improving the land. This is a similar position taken in the Daincourt's case, as the ornamental statues in the garden and house were an integral part of the architectural design of the land, which made them fixtures. Moreover, to support this similar position, in Berkeley and Pullitt in 1976, the Court of Appeal had argued that the purpose of annexation test was preeminent over the fact of physical attachment. Nonetheless, Scarman, Lord Justice, concluded that there is a close relationship between the two. There is significance in discovering the extent of physical disturbance of the building if the item were to be removed from the property. If the item cannot be removed without serious damages, the higher probability that the chattel or the item being a fixture is solid. In applying all these cases and principles, in Abraham's case, the exquisite paintings and sculptures from the Victorian era may be regarded as fixtures rather than mere chattels. This is because the paintings, although easily removable, as stated before by Blackburn and Holland and Hodgson, an article that is affixed to land, even slightly, is to be considered as part of the land. This principle would only be irrelevant if Brenda bore the burden of showing intention of the paintings to be chattel clearly during the visitation, in which she only vaguely answered that a discussion would be made further if Abraham had immediate purchase of the property, with judgments both from DN Court and Ham's cases respectively, items that would form part and parcel or played an integral part of the architectural design would be regarded as fixtures. Additionally, in Scarman in Berkeley's case also argued that if an item was removed from property in resulting serious damages, the case of the item being a fixture is solid. Marble sculptures were extremely heavy in nature and were placed strategically around the property to enhance overall aesthetics of the Victorian property. This would signify that if the sculptures were removed, the great weight may cause damage to the house as it gets moved around, and the property would no longer be regarded as Victorian style. Thus, both the exquisite paintings and the sculptures can be strongly argued to be fixtures rather than mere chattels, because when removed from the property, it would no longer make it Victorian style. This gives rights for Abraham in suing Brenda for breach of contract and retrieving the fixtures back to the property as the items were removed from the property after the purchase. Now we will be moving forward as to the importance of the purpose of paintings and sculptures to the overall value of the property and the intention of the parties when signing the agreement. The first point that I would like to highlight is that the purpose of the paintings and sculptures was to enhance the design of the Victorian style property. Brenda had stated that it would be common sense in excluding the paintings and sculptures as they were chattels to the property, and the value of these chattels were high and would not be included in the value of the property. However, if Brenda had known that the value of the property would be worth more, if she had intended the paintings and sculptures to be chattels, she should have made it clear during the visitation to Abraham, as mentioned before in the case of Holland and Hodgson by Blackburn, that there is an honest that lies to those who assert such items to be chattels. In this case, Brenda's response was only a vague one, and she did not have an assertive answer with intent to illustrate that the painting and sculptures were mere chattels nor fixtures to the property. The moment an owner of a land has entered into a contract to sell, he is no longer entitled to remove fixtures since they belong to the purchaser. This is because the contract operates to transfer the equitable ownership of the land to the purchaser immediately. Brenda had also denied the claim in which she had the intention to sell the property, inclusive of the paintings and sculptures, as none of the parties had brought up the inclusion during the purchase, nor was it stated in the sale and purchase of the agreement. We can now look into reference of the case of Taylor and Hammer in 2002 as express reference to a contract of sale. Briefly, in the case of Taylor and Hammer in 2002, the plaintiff had bought property from the defendant, and during the inspection, the plaintiff had noticed numerous landscape gardens which were paved with valuable antique flagstones. When the property was purchased, the plaintiff had realized that the antique flagstones were removed, and the grass was laid by the vendor's husband in hiding this removal. Before agreeing to the contract, the plaintiff was made aware of the slabs stacked at the side of the property and had asked whether these flagstones were to remain within the property, in which the defendant had stated that they were not. As concluded by the court that the flagstones should be returned and relayed, a reasonable person would have considered the flagstones to have formed part of the contract. Landscape gardens were included in the sale as they were present during the viewing of property. The plaintiff was reasonable in assuming that the flagstones had remained and were going to pass to him. He was entitled to recover the flagstones and damages to cover the cost of relaying them. And the defendant's deceit did not allow the plaintiff to rely on the deemed inspection clause. And the defendant had actually attempted to conceal the removing of these flagstones, which formed dishonesty. Essence of relying the principle of caveat emptor is the fact that you are supposed to allow your purchaser to make their due diligence in actually inspecting the property that is being purchased. There was deceit from the defendant that did not allow the plaintiff to rely on the principle of caveat emptor. Purchasers may be entitled to be confident in understanding that when an agreement is reached, the property which is to pass also includes the fixtures. Similarly, in Abraham and Brenda's case, the Taylor's case illustrates that although there is no provision that was made in the sale and purchase agreement in regard to the antique flagstones, during the viewing of the property, the flagstones were present and the plaintiff was there to see it. So it was reasonable to assume that it had formed part and remained of the property. In Abraham's visitation of the Victorian-style property, had the paintings and sculptures be present, he too would assume that they would remain in the house as he purchased it. A previous owner of the house would only have the rights to remove fixtures if it has been explicitly stated in the contract or before the contract had been signed. However, no express references were made in Abraham and Brenda's agreement. Consequently, Abraham would have also relied on the principle of caveat emptor, which would not be applicable if Brenda had the intention to deceive. It is reasonable for the purchaser to have confidence that the property passed would include fixtures. Moving on now to what I believe that may be the challenges that Abraham may face and the possible outcomes that he could anticipate. Firstly, on the question of fixtures or chattels. Abraham was aware that the paintings could be easily removed and the sculptures were made of marbles which were extremely heavy to be moved around. However, with how it was strategically placed around in the property, he would also understand, or he would also place the trust and confidence that these items are not mere chattels, but were also fixtures that formed part of the property. And this is because the items were placed to enhance the overall aesthetics. Hence, the paintings and sculptures may form part of the property if we were to measure the degree and the purpose of annexation. Secondly, what was meant in communicated the same? When he says that he had communicated the same with Brenda, what exactly were communicated between both parties? This would be questioned by the courts to see if the matter of paintings and sculptures were ever further discussed as Abraham made the purchase, although the items were not stated in the sale and purchase agreement. This may bring forward a questioning whether or not these items were genuinely made aware to be chattels to Abraham, or if Brenda had any intention to actually sell the property with the items, which were the paintings and sculptures, inclusive to be within the sale and purchase agreement. Thirdly, would be that if there is more evidence to show that Abraham was deceived and could not rely on the buyer beware or caveat emptor principle, as illustrated in the case of Taylor and Hammer in 2002, Abraham may also be entitled to recover the damages for the cost of relaying and also be able to sue Brenda for the breach of contract. That is all for me in my presentation. I hope that you enjoyed listening. Thank you.